Lawyers argued that his transfer from Kgosi Mampuru Correctional Services in Pretoria to Ebongweni Supermax prison in KwaZulu-Natal is crippling their efforts to consult with him ahead of his escape trial in Bloemfontein, and accused Correctional Services of unprocedurally and unfairly moving him.
We are in the middle of main trial preparation. When they move him like they did, it has now affected our preparation completely, because he has been moved 750 kilometers away from us. And when he's moved 50 kilometers away from us, it makes it necessarily impossible for us to be able to consult. Why so? We cannot drive daily from Pretoria because the instructing attorney and the counsel, myself, we are based in Pretoria, to Ebongweni, Kokstad. It will be quite cumbersome financially, energy-wise, and otherwise. So we are raising these issues to say we have a trial that we are in. And already in that trial, we have been reprimanded by the presiding officer, the judge in Bloemfontein, that Thabo Bester's team seem to be wasting time, not wanting the matter to sit down because of some of these applications that are lingering. Now, we are requesting that he be brought back on urgent basis so that when we go to court on the 18th of March, we are able to argue to set the matter down properly, since that is the last case management as we've been warned by the court.
Lawyers representing the state meanwhile argue that Bester's lawyers failed to afford substantial reasoning to demonstrate urgency.
There are requirements. You can't just run to court as you please. And the first of those are that you must set out explicitly the circumstances that you say render the matter urgent, and you must explicitly deal with the reasons why you say, the applicant, that you would not be afforded substantial redress at the hearing in due course. Now, what the applicant has done in this matter, it has afforded the respondents 1 day to file a notice of intention to oppose and 1 day to file an answering affidavit. Let's just contrast that to what the rule maker considers to be reasonable in the ordinary situation. 10 days for a respondent to consider an application, take advice, and decide whether he or she or it needs to oppose it. And then a further 15 court days to file answering affidavits. That's the ordinary time periods that Rule 6 caters for, that the lawmakers deems to be reasonable. The applicant here has afforded 1 day to give opposition and 1 day to file affidavits. And my lady, that is not only severely truncated, that is not, extreme is not even the word. It's ridiculous.
Well, Judge Elizabeth Kubushi found that Bester's lawyers' arguments for urgency lacked, and that the matter had not been properly enrolled.
There is therefore no cogent reason mentioned in the founding affidavit why this matter was set down on such stringent time frames without giving the respondent adequate time to file their answering affidavits. I am thus not persuaded that this matter is so urgent that anything more drastic than enrollment on the motion roll in the ordinary course and on short notice is required. The matter is to be struck off the roll because it was not properly enrolled, and the applicant is at liberty, if he so wishes, to enroll it properly for the next urgent court roll.
So this means that Thabo Bester will remain at the Ebongweni Super Maximum Prison while his lawyers decide a way forward. Griselda Lewis, SABC News at the High Court in Pretoria.